1.
This Honorable Court of Tennessee is now in session.
Thank you, Ms. Kraft, and on behalf of Judge McBrayer and Judge Golden, we welcome counsel to this oral argument, which we are live streaming in order to fulfill our obligation to maintain open courts. We will conduct the hearing in the same manner as if we were all together in the courtroom. Each of you has 15 minutes, and I understand Mr. Oldham has requested a rebuttal of 4 minutes. There being no announcements, Ms. Kraft, please call the case.
In re of Tristan H.
And Mr. Oldham, you have the floor.
May it please the court, I'm Bruce Oldham here on behalf of the appellant, the father in this case. This is a termination of parental rights case out of Sumner County. The court terminated parental rights based on 3 grounds. One of those statutory grounds.
Mr. Oldham, I'm sorry to interrupt you, but I had some preliminary questions concerning jurisdiction in this case, because we've noticed a couple of things. One, just starting with the fact that the order itself does not seem to be in compliance with Rule 58. There's no certification from the clerk that the order was sent to everyone. I've got other concerns, though, about the fact that the mother wasn't even listed on the notice of appeal. There's no certificate of service to her on either of the appellate briefs. There's no indication that the mother is in any way involved in any of this, even though her rights were terminated. And I understand that ultimately she was served by publication, although there's no indication of an affidavit from DCS as to diligent search and whatnot. But there's no indication that any of these documents were served on mother at her last known address or anything. I mean, what's the response to that? What do we do with mother here?
Well, that's a good question. Yeah, she did not show up and participate in the trial. She did have counsel present. He requested.
But the judge allowed counsel to withdraw before the trial.
He did. And so he didn't actually participate in the trial. I don't think my client knows where the mother is. So she was served by publication. And I'm not the one who prepared the notice of appeal, but I don't know how we would have served it on her since we don't know her address.
Was there ever any attempt to serve her at a last known address? That, as far as you know?
I don't know. That would probably have been done by the DCS counsel who did the termination. And I didn't handle this in the trial court, so I don't know what efforts were actually made to locate her.
All right. Thank you.
All right. As I was saying, the trial court terminated on 3 grounds. One of those has not been opposed and briefed by the state. That's persistence of conditions. So I won't get into that unless the court wishes me to do so. The other 2 statutory grounds involve the failure to comply with the permanency plan and failure to manifest a willingness and ability to take custody of the child. The father contends that he did, to the best of his ability, comply with the plan. He did get a drug and alcohol assessment. He did have regular visits with the child, although they were supervised. He did at one point ask for additional visitation. So he has maintained regular contact with the child. He had employment at one time and got COVID, lost that employment because of COVID-19. At the time of the trial, he was receiving regular income by unemployment. One of the biggest issues had to do with his housing. He lives in a 2-bedroom home with his mother and a disabled brother. There is kind of a troubled relationship with the mother. I'm talking about my client's mother, not the mother of the child, Tristan. But just due to his financial circumstances, he has not been able to secure other housing. It's very difficult with the cost of rent and the cost of living to do so. He has had trouble having a lack of vehicle to get to and from employment. At the time of the trial, he'd been able to get a vehicle and was working toward securing other employment now that he could get to and from employment. So we contend that the father was really doing the best he could given his limited means and circumstances. I know another troubling aspect was alcohol and drugs. A lot of that had to do with the mother's drinking, and she just kind of disappeared from the picture, seems to be no longer in the child's life. The father had maintained sobriety by his testimony. He had failed a couple of drug screens for amphetamine and methamphetamine. He contended that as far as the amphetamine, it was because he was taking Adderall, a prescribed medication. The methamphetamine, he contended, was a false positive. He did fail to show up for at least one or two hair follicle tests. He testified that was because he was in quarantine for COVID. So there's just not clear and convincing evidence, we contend, to show that's really an issue. As far as manifesting a willingness and ability to assume custody, the trial court said he had the willingness, but not the ability. A lot of that, again, turned around the issues with housing, which just has to do with his being underprivileged and living in poverty. And he does have a home. He may have issues with the mother, but he does have housing. He's not homeless. And as far as the best interests, even the foster mother testified that there is a bond between the father and Tristan. Tristan calls him daddy. He has maintained regular visits and contact with his son. He has tried to do what he can, and we believe that it's in the child's best interest that rather than terminating parental rights, that this should be remanded with instructions to create another permanency plan with a goal of reunification and give the father a chance to comply with that plan, with him realizing that if he doesn't do it this time, he's out. But at least give him a chance to reunite with his son. And unless the court has further questions, that's all of my initial argument.
All right, thank you, Mr. Oldham. We'll now hear from the appellee.
May it please the court. Good morning, Your Honors. My name is Courtney Mohan. I'm with the Attorney General's office, and I represent the Department of Children's Services in this matter.
Ms. Mohan, let me start with you and ask you the same questions I asked Mr. Oldham about how we have jurisdiction in this case based on the status of this case where the original order is not in compliance with Rule 58. The mother is not listed on the notice of appeal. There's no certificate of service on either of the appellate briefs to her. There's some question as to they're lacking an affidavit as to there was ever any attempt for diligent search and inquiry. Where are we on this?
Your Honor, I do see in the technical record that there was the notice of publication, at least initially in the case.
I did see that there was publication.
Yes,
There was
I
no
did
indication
not.
that there was any attempt. There's nothing in there indicating that as to what attempts were made to locate her prior to the time that there was an order of publication. But regardless of that, the order does not have a certificate of service certified by the clerk. It's not in compliance with Rule 58. She's not listed on the notice of appeal, and there's no certificate of service from either you or Mr. Oldham as to her on either of the appellate briefs. What do we do with her at this point? She's
I believe
on this order, but she's not part of this appeal.
at this point we just move forward with the father, but I would need to be able to research this, be able to answer it with.
Well, the order did not designate that this was only final as to the father. It designated it was final as to both mother and father. So how do we move forward only as to father?
And I would need to be able to research it further.
All right, go ahead.
In this case, we have a child that deserves permanency and a father that has proven himself to be inconsistent in his efforts to regain custody. The Department of Children's Services is proceeding on 2 grounds on appeal that were found by the trial court. That was substantial noncompliance with the permanency plans and failure to manifest a willingness and ability to care for the child, as well as the father's rights were terminated as they were found to be in the best interest of the child to be terminated. Looking at the first ground, which is substantial noncompliance with the plans, the father did participate with the creation of the plans and was aware of his requirements, yet he was substantially noncompliant for a number of reasons. He did not properly engage in substance abuse treatment, and while he was initially compliant, he fell out of compliance after positive drug screens, and at that point refused to complete drug testing and refused to complete additional treatment. He also failed to complete individual therapy. There was some confusion noted in the record on that. However, the trial court found that the father failed to consistently engage in individual therapy since 2018. The father also did not engage in domestic violence counseling, which is notably one of the more concerning aspects of the permanency plan that the father did not engage in. Concerning because during the custodial episode, the father was arrested for and later convicted of a domestic assault involving the grandmother in this case. That incident was concerning given the father's threats to shoot the grandmother as well as to shoot up a women's shelter. And when he was arrested, a firearm was recovered from the home. Looking at the housing, the trial court noted that the father failed in this extremely key area to provide safe and stable housing for the child. The father made promises, but those were not upheld. And the trial court noted concerns not only with the domestic violence within the home, but also the grandmother's request for the father to leave and vacate the premises, as well as the continued police presence in the home. The trial court noted that this situation is far too tenuous to find safe and stable housing was had in this case. When DCS attempted a home visit in this case, the father refused to let DCS inside. So while we don't know the physical nature of the home, even setting that aside, it's the people within the home that are causing the issue. We have the father who has picked up the domestic violence case involving the grandmother within the home, but we also have the grandmother who threatened to kill the foster parent during the custodial episode. The father indicated at the trial that he did not plan to stay at the home, so at this point it is unknown where the father was planning to go next if custody was to return to the father, as well as his plans with Tristan moving forward. As found by the trial court, there is clear and convincing evidence that the father was substantially non-compliant with the permanency plans, and this ground should be upheld. Looking next at the second ground, which is the failure to manifest an ability and willingness to assume custody of the child, the father in this case failed to present an ability and a willingness to assume custody. Much of the same evidence for the first ground regarding the permanency plans applies when looking at the ability and willingness of the father. In looking at ability, which looks at the father's lifestyle and circumstances, his circumstances are up in the air. He does not have safe and stable housing. He lacks a plan if the child is returned to his care, and he has unresolved treatment needs in the form of substance abuse, mental health, and domestic violence. When we're looking at willingness, we look at more than a parent's words, but we look at their attempts to overcome the obstacles that are preventing reunification. Again, the father was not compliant with the permanency plans in this case, and there's unresolved treatment issues that present a great deal of concern regarding his willingness to assume custody of his child. The father has said that he was wanting to assume custody, yet he did not make any significant changes since 2018. And as the trial court stated, at some point, promises cannot be enough and chances have been exhausted and change must occur. In looking at the second element, which is substantial harm to the child, there's a substantial risk of harm to a child to place that child in a home when a parent has unresolved substance abuse, mental health, and domestic violence issues. Particularly the 2020 domestic violence incident involving threats with a firearm and a firearm that was recovered on scene are particularly concerning. The trial court also noted a concern with the father's ability to appreciate his son's medical needs if his son was returned to his custody. The father's lack of progress is contrasted by how well the child is doing in foster care. The child is progressing in foster care and has a strong bond with his family, and the foster mother wishes to adopt him. For these reasons, there is clear and convincing evidence that the father failed to manifest an ability and willingness to assume custody of the child, and this ground should be upheld.
All right. Anything further, General?
I lastly wanted to note just the best interest factors, really focusing on factor 5, which looks at the change in caretakers. And again, noting that this child has progressed greatly in his home. The foster mother has helped the child overcome delays that he was experiencing when he entered the home and has prioritized not only his regular everyday needs, but also his medical needs and well-being. And he has a strong bond with his foster family. This is a child that needs and deserves permanency, and it is in his best interest that his father's rights be terminated. And so for these reasons, DCS is asking that the court uphold the trial court's order to terminate the father's parental rights.
All right. Thank you, General. Mr. Oldham, your rebuttal.
Thank you, Your Honor. As far as the father's failure to receive therapy, I think the trial court found that he had some confusion. He was indeed receiving medication therapy, but not talk therapy. Just don't know that it was ever made clear to him what he was expected to do under the plan.
Well, but the third plan made it more explicit, didn't it?
It probably did, but he was also, at that time, we had COVID coming in, so I don't know how easy it would have been for him to get additional therapy. As far as the criminal charges that took place involving my client and his mother, he testified that he only pled guilty to that so that he would not risk losing some of his visits with his son. That's really all the rebuttal I've got, other than since the court has raised these issues about jurisdiction, whether there was a sufficient due diligence affidavit to do the publication, and failure to serve the order on the mother, which could result in the order not being a final appealable order, I would ask that we be given some period of time to do a supplemental brief on the jurisdiction issue.
All right. Does the court wish to weigh in on that suggestion?
I think we should discuss that and then we can enter an order.
All right, Mr. Oldham, the court will consider your suggestion, and if we want additional briefing, we'll put an order down. But if we choose not to ask for additional briefing, we will not put an order down. All right, thank you both for your arguments. We will take this matter under advisement. Ms. Kraft?
The Honorable Court of Tennessee is now in recess.
Thank you, counsel. You're free to exit the Zoom meeting.